You have a statement a couple of times in your brief. You say you're not challenging the use of testers in ADA litigation, and principally distinguish this case to one where there's an attempt to enter a building. So I guess I'd like to hear what you mean by that, and what you think would be permissible, and why it's different from this case.
That's right. So we've distinguished the scenario where someone is actually trying to physically enter a building, and but for the accessibility barrier, the person couldn't enter. And that's because we understand the inability to access a building as a traditional Article III injury, regardless of the motive for entering the building.
So suppose that you were trying to enter a hotel, but you didn't really want to stay at the hotel.
I think that probably would be if you were physically prevented.
But you want to go in.
That's right.
Same like you want to enter a concert venue even though you don't want to stay for the concert.
So every court of appeals to have addressed the question Your Honor just described has found standing on those facts, and so we haven't contested that in our briefing.
And I presume that that's similar, I mean, tell me if you think this is wrong, to let's say that there's a blind person who can't access a website at all because there's not the appropriate technology for the visually impaired to make use of the website. Would you say also that that's sort of like the person who wants to enter a building, that and the visually impaired person is in fact a tester and is just checking out different websites?
So we actually haven't taken that position. There's three courts of appeals decisions, one of which was written by then Judge Barrett, involving visually impaired testers who go to websites of credit unions that they weren't even statutorily eligible to join, and those courts held that the plaintiffs did not have standing, and we actually think those are correctly decided.
Yeah, I understand that, but if a person is checking out websites in the way that it's not like I'm eligible to join the website of a particular company, but just in the way we all check out websites and can't do that, whether the fact that he was a tester could prevent the person from making a claim.
So I don't think the person has standing, but even if you disagree, our case is different from that. So the first part of my answer is I don't think so. I think that, as in the case of the credit unions, merely trying to seek information about a service you don't want, I don't think that's an Article III injury under TransUnion's discussion of informational harm. But the second part of my answer is that even if you think I'm completely wrong on that, I think that's distinguishable because in that case, the plaintiff was prevented from using the website. In this case, we think what really happened here was that there is a bar to accessing the hotel, which doesn't become relevant until the plaintiff tries to do that.
Thank you.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
I have a question about some of Justice Sotomayor and Justice Kagan's hypotheticals. I mean, it does seem like they're all meaningfully different in the injury sense, and I'm wondering whether, I'm thinking about a plaintiff who tries to make a reservation at Acheson Hotel and then just gets frustrated because she's disabled and she can't get the information, so she says, I'm not giving this place my business, but I want to sue. Like, I would never go stay there because, and I'm not going to go back to the website because I'm offended. This isn't a place that I want to frequent. Do you think that person has suffered an Article III injury?
Yes, but they couldn't sue because you can only get an injunction.
Injunction relief. Yeah. Okay, so that's my question. You're not taking the position that my plaintiff hasn't suffered an Article III injury, but you're saying here that the forward-looking piece of it is because you have to show that you have standing for the relief that you seek, and the ADA only permits an injunction.
The injury has to be in the future, correct.
Okay, thanks.
Justice Jackson?